Okay. Newsletter 2 for 2014 gets into a lot of real issues now. So, first we're going to look at a couple of court cases. Some of them are slightly interesting, but nothing really landmark. I'd say they're all of moderate significance. We're going to examine what I believe is a shift of the current program from tax credits, what they call indirect funding, to grants, direct funding, and the reasons. I mean, it gives politicians more opportunities for pictures. It's easier to administer. There's no risk. You give a budget. When it's gone, it's gone. There's really no right to a grant. It's completely discretionary. They can give you a grant or not. You can't say, well, I did this work and the income tax gives me the right under law to get this money back. So, again, for politicians, it has a lot of advantages. We'll talk about the new BDC loan program. It just came out. Some new CRA SR&ED pronouncements for reporting preparer fees and how they've relaxed a bit, how their new position. Something that they call the self-assessment learning tool. We can look at that briefly. And then we'll talk about changes to the Tax Court of Canada. Some of the recent changes in the law, stock options, new rules on control. And lastly, I'll close it off with what are people talking about in the media for SR&ED? And there's really some neat news sources. I don't know if anyone here uses LinkedIn. It's kind of like a social media platform, but there's three very large groups that deal with SR&ED issues, 2 in Canada and 1 internationally, and some interesting issues that we brought up that we'll reiterate here, or opinions on the SR&ED program. And then we'll talk about, there's this couple of guys in the Globe and Mail who keep publishing these articles that I think are very misleading. And every year I have another article by this guy, and I say, oh man, what's this guy going to come up with next? So we'll talk about how he offended me this year. All right, so we'll go through these 3 to 4 cases. We might revisit Air Max briefly. So FIO is an interesting case here. So what happened was the client disagreed on a SR&ED claim and said, you know what, I'll file my objection, I'll wait my 90 days, and then I'm going to appeal to the Tax Court of Canada. Okay? And one of the things that I find is misunderstood right across the board by claimants, by practitioners, and particularly by the CRA, is the difference between an objection and an appeal. Okay? And these are tax terms. CRA makes this really complicated because they call their objections division the appeals division. And therefore, people use the term appeal. But when you file an objection with the CRA under Income Tax Action 165, that's called an objection, technically. The legal name is an objection. Okay? And that gives the CRA the chance to deal with it internally. And you have the right to wait 90 days or wait for their response. If you don't like it, then you can appeal to the Tax Court of Canada. Okay? So that's a complete other section of the Act. Once it goes to the Tax Court of Canada, CRA is no longer involved. CRA is what they call the client of the Department of Justice. And Department of Justice is the one that you're dealing with head-to-head. So there's Department of Justice, Crown Counsel, and there's you, and there's the judge. And the judge asks questions, and you try to provide the information that's going to allow the judge to make an informed decision on whether it's SR&ED or not. And they're going to ask very detailed questions. What happened here is the client went to Section 169. They filed an appeal and submitted information. CRA used this information to reassess them on other issues. Okay? They then said that's a violation of the Income Tax Act, and they sued the CRA for $100,000 in damages. And basically the judge said, the CRA's defense is, well, we think that the rules on not using that apply to claimants, but not to us. We're allowed to use any information. And the judge said, no, the tax court rules are very clear. Once it goes to tax court, the CRA is not allowed to use that information. It's inadmissible for any other assessment purpose other than the tax court. And so he said, well, CRA, you did a bad thing, but I think $100,000 is too much. I'm going to award $25,000 in damages and a severe reprimand. That you cannot use tax court CRA cannot use tax court information to assess you on other issues. It has to be used exclusively for that purpose. That's about it. This case probably doesn't have too much long-term significance other than to illustrate something that's very prevalent right now. So I see this all the time. Client who's claimed SR&ED successfully, never a problem, 8 years in a row, they got 100%. And all of a sudden, denied. None of this is eligible. I get guys calling me like every month, what? Hey, I'm doing everything, how could it all be eligible before and now nothing's eligible? Like, what happened? Siri's saying there's no policy changes. They're just cracking down a bit on people who shouldn't have got it in the first place. And we'll talk about whether they're doing this effectively or ineffectively and how they're communicating it. But basically, this client took the wrong position. That their only defense, rather than saying, well, I got timesheets, or I got a notebook, or I'll try to reverse engineer something to support my time, is that it was a husband and wife in there, and they were both accepted 100% for numerous years, and in the final year, the husband was allowed to claim 25% of his costs. He claimed 100, so it got reduced by 75%, and the wife's fees got completely denied. And their only defense is, you should consider how we did it in prior years. What's the big deal? Give us our money, which is the wrong defense. Because again, the judge is going to say, well, we shouldn't have given it to you in prior years. We've got to get the time reporting requirements and keeping the evidence. So again, it's a weakness of, I sympathize with the client because the client probably wasn't warned, wasn't told about this, thought everything was cool. Hey, I've got all my claims. I've never had a problem. And not, hey, we're going to knock out 20% or we're going to write you a stern, we're going to give you your money this year, but we're going to write you a stern letter about next year so you've been warned, which is more commonplace. They just knocked them right out. So again, I think a lot of this is at the discretion of the reviewers, and it started around 2008, 2009, but it's really become prevalent in the last 2 to 3 years. So from 2011, 12 on, you see more and more of this type of incident. That certain, and it's not all reviewers, it's certain reviewers have a different style, and it's a poor communication style or whatever you want to call it. But I think the implication is they're really stressing real-time documentation. Don't leave everything to the year end. Try to document, whether it's just a daily lab book or a journal, or anything that you can to document what you're doing. More importantly, how it relates to the uncertainties. So again, ultimately, if you can tie it to variables, I think that's the ultimate, but somehow talk about how what you did relates to one of your technological problems. Okay, Coveley. This is actually a very complicated case, but it illustrates a bunch of interesting kind of tax, maybe not SR&ED ideas, but integrates some cool planning ideas. So what happened here is that Mr. Coveley was a technical engineer, so he had the technology background. He was a chief technology officer of a company, but he wasn't a shareholder. His wife was the president, CEO, and she also owned the company. So you had two spouses. One owned the company, 100% of the shares, and one had no ownership. Okay. We're told that starting in late 1998, they started making loans to the company. So they started lending their company money, and a lot of the loans were actually unpaid remuneration. Okay, you owe me $100,000 for work. You haven't got any money, so you owe me $100,000. I'm saying that's a very effective tax planning tool. That if you have a small company, startup, or doesn't have a lot of cash flows, often people will work on what we call sweat equity. I see the owner, who started his own company and he left his job in industry making $200,000 a year, and he's living off his life savings for the first year. And you look at it doing his tax return and say, "Wow, how does someone live off $8,000?" They really live thriftily. They don't pay themselves what they're worth. They pay themselves what they need to live, like to eat and get to and from the office, and that's it. And everything else is going into the business. So I could do a claim and claim the $8,000 of salary, 100% SR&ED. But realistically, what I want to say is, well, as a specified employee, your limit is 5 times yearly maximum pensionable earnings that you can claim for SR&ED. This is roughly $250,000. So let's say we paid you $8,000, but we owe you another $240,000 for the work that you did, because you did $250,000 worth of work. And we'll claim all of that, because there's a line on the T661 for wages that are paid, and another one for wages that were incurred in the year for SR&ED, but not paid within 180 days a year end. And that's a great anti-avoidance provision that you can use as a tax planning tool. So I'll accrue all my wages for each year. CRA has the right to review it, check it, that I did a full year's work. That's fine. It's got to be submitted with the T661 when I file. And once they approve it, in any future year where I show, here's my withholdings to pay the income that I accrued there, I just get my credits. You just put it in, you get your credits now. You lose your proxy, if that's what you're going to say. Yeah.
No, I know that. What about the provincial? Sometimes they don't match.
What do you mean by that? Provincial?
Provincial doesn't, I can tell you in Nova Scotia, for example, you do not get the ITCs.
Oh, I was unaware of that actually, but that's a good point. I don't know why that would be. Are they not in a green province, or their act says something different? Oh, okay.
They have their own income.
So you want to be careful in some provinces, but in most cases, like in Ontario, that would be fine. And that's the way it's supposed to be. They're saying that's no problem. If someone did $250,000 of R&D work and you couldn't afford to pay them, but they really did the work, then if you ever do make money and can't afford to pay them, you get the credits for that work whenever you pay them. Nothing abusive about that. SR&ED doesn't mind, because when you pay them, they get their personal tax, probably 40 cents on the dollar, and they kick you back, on average 15 to 20, because most claimants are 15%ers. They're not. And if you happen to be one of the few, small companies that claim, maybe you can break even or get a little more back, but not much. It's a completely hedged transaction. Whatever you pay in personal tax is probably as much or more than they're going to pay out. Now, this is sorry, I'm not getting on the ABIL side, so we're mixing apples and oranges there. But hang on, Harvey, let me finish on that. So, to pull this back around again. So, I'll talk about that tax planning tool. It's a good tool. What happened in here is they owed themselves all this money, but they never actually paid it to themselves, and then they tried to claim an ABIL. And there's a whole bunch of issues here. So the question one is, are both of them entitled to claim an ABIL? And since Mr. was not a shareholder, he's got no entitlement to claim the ABIL. But his spouse, since she was, would be entitled to claim an ABIL. The other issue is, when are they entitled to claim the ABIL? And I didn't list it here, but the facts were they were continuing to pump money in this company. They were doing ongoing development. And ABIL's for a company that's dead or dormant or has no reasonable expectation of coming back alive again. And really, they were showing that that this may eventually become an ABIL, but not in the year that they said, because in the year end, proven in subsequent years, they were actually conducting full business. So an ABIL is good, but if the company's still active at the end of the year, you might have a hard time claiming an ABIL. You may say, well, I don't think this company's ever going to make me any money or anything, but that's a little bit different than what's required for an ABIL. So there's some judgment on the company's supposed to be dead, insolvent, wound up, or reasonably expected to do so if you read the legislation. And in this case, the judge did not feel that they met that second criteria. So they may eventually have an ABIL, but not for the year in question. All right, so just some tax planning. I think it's more interesting because of the accrual issues and how that worked.